already applied for a protection order against them, and they appear in court on the 12th of December 2025. Applicant said he does not know the deceased or any other person that came to the flat, nor has any contact with them, as this was communicated by his girlfriend through WhatsApp. Applicant further stated that nothing illegal was found in his possession. He and his girlfriend were taken to the police station, then after to the court, where the charges were withdrawn against his girlfriend due to lack of sufficient evidence. He alleged his girlfriend never made any statement to the police implicating him to the offense. The police are fabricating evidence, and they have arrested the wrong person. He deserves to be released on bail while waiting for the investigation in this case. Should the court decide to grant him bail, he had 8,000 rand available. Applicant also submitted an address verification statement written by a ward councillor, Mr. Gift Mate, who stated that Victor Majola is a resident in his ward, staying at Mapetla Hostel, Block 3, Room 50. This verification statement was marked as Exhibit B. He also submitted a statement from Eusebio Wate, who stated that Victor Majola was at his work address on the 16th of December 2025 for fixing his vehicle, and that Victor Majola could not have been at any other place because of he was with him. This statement was marked as Exhibit E. Lastly, in his evidence, the applicant submitted a video footage of the incident, which was marked as Exhibit 1, as well as the photo that was zoomed from the video footage. The photo was marked as Exhibit F. I will comment on this video footage later in my judgment. Regarding his exceptional circumstances, he stated that the state case is weak. The state case is based on a single witness. There is no video footage because of the state failed to produce it. The ID parade was flawed. Witnesses cannot describe him. Police failed to read his right during the arrest as well as at the ID parade.
Amaphoyisa ahlulekile ukuthi atshele noma achazisele amalungelo akho ngenkathi-ke kubanjwa phecelezi i-ID parade.
That is the evidence of the applicant.
Ubufakazi bakho lokho.
I'll proceed with evidence of the state.
Uzoqhubeka manje ngokushiwo kwabafakazi bakamtshutshisi.
In turn, the state opposed his application, and the evidence of the state is as follows.
Umtshutshisi uyala ukuthi udedele ngebheli ukuthi ufakazi kungale ndlela elandelayo.
Captain Muntwedi stated that he is the investigating officer of this case and he's stationed at provincial unit in Gauteng, holding a rank of captain.
Uthi uCaptain Mxwedi uyena-ke uphoyisa eliphethe leli cala usebenza lapho provincially-ke futhi uCaptain.
He stated that there is a Zambezi flat at corner of Van Vellach and Commissioner Street in Johannesburg, CBD.
Uthi kukhona iZambezi flat ekhoneni lakaFonvala neCommissioner Street lapha-ke edrobheni.
The owner of this flat passed away and his son, Sean, inherited the flat.
Umnini wendawo washona-ke kwasisekile ukuthi indawo yatholwa indodana yakhe uSean.
And Sean took over the responsibilities of managing the tenant in the said flat.
Kwase-ke ethatha ukwamukela i-responsibility ukuthi-ke kube uyena ophathayo lapho efletini.
Sean realized that he was no longer making enough profit as before. He then investigated.
uSean wabona ukuthi akasayenzi i-profit nenzuzo-ke ehlale yenza ngaphambi wasebona ukuthi ngcono aphenye.
And found that there are people who are collecting money from the tenant.
Wathola ukuthi kukhona abantu abazayo ama-tenants bathathe iy'ndana.
He then decided to appoint the deceased Mr. Warrick Stock Company to assist him with the installation of biometric securities at the flat.
Futhi waseseke bona ukuthi-ke aqashe umnumzane Warras ukuze-ke manje iqembu libe khona lifake-ke uhlobo olusha-ke lokuthola lokukhona ukubona umuntu ukuthi ngendlela ukuthi noma ngendlela efanele ukuthi-ke ubani ungenayo yasikhathi kanjani.
Captain Muntwedi said, amongst the people collecting money from the tenant, it was applicant, girlfriend Hlengiwe, and her team.
Abanye abantu-ke ababekolekta imali-ke lapho bethina omunye wabo intombi yakho uHlengiwe.
Captain Muntwedi said the deceased, before he may install the security at the flat, he called a meeting with all the tenants from Zambezi flat.
Uthi ngaphambi kwafaka lo hlobo olusha-ke endaweni-ke phambili ukuthi-ke ukhona ubheka indawo uvikele leyo ndawo uthi wabiza inhlangano ngaphambi wonke umuntu owayelapho ama-tenant.
During that meeting, applicant girlfriend and her team were not happy about the new system which will be installed.
Manje ngaleso sikhathi kungena lo mhlangano ukhethiwe naye intombi yakho babengeneme-ke ngale system lendlela entsha efakwayo lapho.
They told the deceased that he cannot take the money out of their mouth, and should he install the security, they will show him.
Uthi bamtshele watshela-ke umuntu ukuthi akwazi ukuthatha imali imali yomunye wabo mangabe ezothwala lelo lusha bazomubonisa.
The deceased felt intimidated and he applied for a protection order against the applicant girlfriend.
Ukuthi-ke manje ufakazi lona noma umufi wasebona ngcono ayofaka isicelo se-protection order.
As well as the others. All in all, there were 5 in number.
Uthi nabanye-ke bebonke labo bantu labo abakwenza lokho babebahlanu.
Copies of the protection orders were marked by the court as Exhibit D1 to D5.
Uthi-ke bonke-ke ubufakazi balawo bantu lawo amakhophi lawo-ke aqala ukuthi 1 kuya ku-5 akhombisa
The deceased, in his protection order, he stated that the respondent and his team the first respondent, which is Hlengiwe Buthelezi, he stated as follows in his application for the protection order that they repeatedly harassed security personnel at the flat and forced them to abandon their post. There was also threat of violence by the respondent as well as an unidentified individual accompanying the respondent. On the 16th and the 17th of November 2025, respondent came to the flat with additional unknown males. During the confrontation there was threat of physical harm and violence. Threat to ban security guard, and this threat was also directed to management. This threat, action, and intimidation were consistently repeated and escalating towards the management. The deceased application for protection order was set for the 12th of December 2025. Unfortunately, the matter could not proceed as the respondent requested postponement for a lawyer. On the 16th of December 2025, the deceased, Mr. Warrick, known as DJ Warras, was at Zambezi flat to install the security system. The deceased went out of the building going towards his vehicle at the parking. At that time, the deceased was on his phone. After he finished on his phone, he walked back to Zambezi flat. That was when he was shot. After the shooting, he investigated the crime scene. He obtained the video footage from the butcher nearby. What he observed on the video footage, he saw the applicant and the other two gentlemen seated next to the street vendor next to Zambezi flat. According to the investigating officer, applicant and the other two men were seated there for 45 minutes before the shooting occurred. He further stated that the applicant and the other two gentlemen waited for the deceased to finish on his phone, and as the deceased walked back to the flat, Rasta fired a shot, and thereafter they walked down towards Fox Street.
Uthi-ke walinda ukuthi-ke manje-ke umufika acted ukukhuluma nge-cellphone, emveni kwalokho-ke wasese-ke ebuyela-ke efletini kulapho-ke nina Mdulu.
Captain Mutwedi further stated that during his investigation, he obtained a statement from the street vendor who told him that applicant and the other two gentlemen were seated next to him. At that time, DJ Warras was coming out of the building, and the applicant informed these other two gentlemen that there is the person, and that's how DJ Warras was killed.
Uthi-ke manje lowo muntu wayedayisa lapho amtshela ukuthi wena nalowo wesibili nanihleli lapho-ke lapho-ke for leso sikhathi leso bese
I'll repeat the whole paragraph again.
sentence by sentence.
I see Mr. Mavuso is saying, can Mr. Mavuso take over? I'll request Mr. Mavuso to take over. Ma'am Pelani, thank you very much. Mr. Mavuso, anyway, he was the interpreter for this case since we started. Thanks. On record, we now assisted by Mr. Mavuso. I will repeat from the paragraph. Captain Montwedi further stated that during his investigation, he obtained a statement from the street vendor who told him that applicant and the other two gentlemen were seated next to him at the time DJ Warras was coming out of the building. The applicant informed these two gentlemen that there is the person, and that's how DJ Warras was killed. As he conducted his investigation, he managed to assign informers. The informer told him that the applicant and his girlfriend went to Mirafe Hostel in Soweto for hiding. He went with the informer to Soweto to show him this hostel. On the 22nd of December 2025, he met with his investigating team and went to Murafe Hostel. They found the applicant and his girlfriend.
Day 22 that December,
he arrested accused alone because of accused misled him that the lady was not Hlengiwe. During the arrest, he confiscated 7 phones from the accused and thereafter they went to Deep Kloof police station. While they were there, someone called Hlengiwe. He answered the phone. When he answered the phone, the caller said, "Are you aware that Majola is arrested?"
waphendula ucingo-ke lo obekafonile wabuza ukuthi ngabe unalo ulwazi yini lokuthi-ke umnumzane uMajola useboshiwe.
Are the photos still there or deleted?
Ngabe iy'thombe zisesekhona lapho noma sezikhishile?
When he answered this phone, the accused was there in his presence.
Ngalesikhathi lesi aphendula lolo cingo, wena okanye nawe ubukhona khona lapho.
He also searched the accused and found Hlengiwe's Capitec bank card.
Wase uyasesha, emveni kokuthi akuseshile wase thola-ke ikhadi lasebhange likaHlengiwe laseCapitec.
And he therefore instructed the team to go back to the hostel to arrest Hlengiwe.
Wase-ke etshela ithimba lakhe lokuthi alibuyele-ke emuva liyobopha-ke uHlengiwe.
On the 23rd of December 2025, he obtained a search and seizure warrant from the court.
May 23 December 2025, wase-ke uthola-ke ulentuzana incwadi enkantolo yokuthi-ke angahamba ayosesha futhi abuye athathe nezinto.
He then switched on the applicant's phone. On the applicant's phone, he found the following: the deceased photos, the deceased car registration document, and the deceased personal details.
Kanti-ke wathi-ke emva kwalokho wase-ke ulayita-ke ifoni yakho. Ngakho-ke wasethola-ke okulandelayo. Wathola-ke iy'thombe zikamufi, wathola-ke futhi ney'ncwadi zemoto yakhe umufi, kanti nokunye okuphathelene nomufi.
He noticed that Hlengiwe, she is the one who forwarded the deceased photo registration document to the applicant.
Kanti-ke into ayitholile-ke lapho ukuthi wena lezo zinto lezo iy'thombe ney'ncwadi zemoto zikamufi wena wawuthunyelwe uHlengiwe.
He further stated that he conducted an ID parade.
Wase uyeqhubeka-ke wase ukuthi yena-ke uye wahlela ukuthi kube nekhomba ngekakhwini kuthiwa-ke i-ID parade.
During the ID parade, the applicant was pointed out by the witness who heard him say, "There is the person."
Kanti-ke kuleyo ID parade-ke into eyenzakala wena wakhonjwa-ke yilo fakazi lo akuzwile lo obonile uma kwenzakala ngesenhlakalo akuzwile uma uthi nangu muntu.
Captain Twedi said the evidence that he had collected, that is the photos, video footage, and the others, they are sent to forensic lab for analysis, and the results are still outstanding.
Kanti-ke umseshi-ke umnumzane uTwedi uyawathathisa-ke futhi ukuthi-ke ubufakazi abuqoqile-ke lapho kwenzakala khona isehlakalo, iy'thombe, i-video footage nobunye ubufakazi obuphathekayo uyobudlulisela laphana kochwepheshe ukuthi kuyochukulisisa kahle.
Regarding applicant personal circumstances, he found that applicant have 6 different addresses.
Kanti-ke ngesimo sakho-ke yena-ke uye wathola ukuthi wena unamakheli ayisithupha ahlukile.
Addresses are as follows:
Amakheli-ke lawo ilawa alandelayo.
1, 286 Zola North.
Kanti yokuqala i-286 eZola North.
2, 177 Mapetla.
Eyesibili ikheli 177 seMapetla.
3, 893 Cosmo City, Randburg.
Eyesithathu 893 Cosmos City Randburg.
4, Msinga, KZN.
Eyesine yaseMsinga KwaZulu Natal.
5, Mirafe Hostel, Block 3, Room 50.
Kanti esihlanu esemlafe hostel Block 3 eroom 50.
6, number 44, Zambezi Flat, Van Vella Street, Johannesburg.
Kanti esithupha i-number 44 Zambezi House Van Vella
He further went to the Department of Housing to verify the properties.
Kanti ke uye wahamba waya ke emnyangweni wazasekhaya okanye wezindlu wafika ke lapho ke ayopenyisisa ngaphansi
And he,
amakheli akhe.
and he found that the accused does not own any of the said properties.
Wathola ke ukuthi ke embikweni awutholile lapho wathola ukuthi ke wena ke ayikho kuwo wonke lamakheli indawo ekungeyakho.
He went to Murafe Hostel to verify the address.
Wahamba ke futhi wabangesemlafe hostel ayophenyisisa kabanzi ngekheli.
The induna at the hostel informed him that accused only stayed there 3 days before his arrest.
Kanti ke induna ayithola ke lapho hostela yamcacisela ukuthi ke wena wahlala amalanga amathathu ngaphambi kokuthi ubonwe.
Therefore, he's opposing the release of the applicant on bail on the following reasons.
Wase ke na ukuthi uyaphikisana ke nesicelo sakho sokuthi bakhululwa ngebheyili ngezizathu ezilandelayo.
He said he does not have a fixed address,
Njengokuqala wena awunandawo ekungeyakho.
that applicants know the scene of the crime and he may interfere with the witnesses and the witnesses may be killed.
Kanti ke okwesibili uyazi la kwenzakale khona lesigameko kanti ke ungahamba uyophazamisa okanye uyohlukumeza ofakazi.
There are still outstanding suspects which the applicant may interfere with their investigations.
Kanti kunabanye futhi abasolwa asaphenya ngabo abangakabotshwa nabo ababandakanyeka kuso lesehlakalo.
That is the evidence of the state.
Yibo ubufakazi ebuthulwe abashushisi.
I'll proceed with the evaluation of the evidence by the court.
Manje inkantolo izawuqhubeka ibuyekeze bonke ubufakazi lobu benabo.
Court found that applicant does not have a proper address.
Inkantolo ithola ukuthi ke wena ke awunayo indawo ekungeyakho la uhlala khona.
Applicant submitted 2 conflicting addresses.
Wena ke unikezele enkundleni amakheli amabili ashayisanayo.
In his affidavit, he stated that he resides at Mirafe Hostel, Block 3, Room 50.
Kuyincwadi yakho efungelo ethulela enkantolo wena ucacise ukuthi uhlala block 3 room 50 Mlazo Hostel.
And he also submitted an affidavit statement by the ward councillor, Mr. Gift Mati, who stated that applicant is a resident of his ward and he resides at Mapetla Hostel, Block 3, Room 50.
Kanti ke futhi waphisana ke ngencwadi ephuma kuKhansela uMnumzana uMathi le ecacisa ke ukuthi ke yena uyikhansela lendawo kanti wena ke uhlala ke eMapetla Hostel room 3 block 50.
These are 2 different hostels, though they are situated in Mapetla in Soweto.
Kanti ke amahostel amabili ahlukile ke lawo noma atholakala ke lapha eMapetla eSoweto.
Regarding the video footage submitted by the applicant to the court,
Mayelana ke nosiqofo lesike nina wena onikezene ngaso la enkundleni.
I had an opportunity to view this video footage.
Ngibe nethuba lokuthi ke ngisibhekeke leso siqofo.
What I have noted from the video footage, it is not clear.
Into engiyibonile ke okanye enginakisisile kuleso siqofo leso akucaci kahle abonakala.
It is blurry
Isithombe sakhona sibonakala kahle.
and black out.
Kanti ke futhi ke kunobumnyama kukhona.
Therefore, the court found that it is not a reliable video footage. Possibly, it may be edited.
Kanti ke inkantolo ibona ukuthi ke lokho kufakazi leso siqofo ke leso angeke inkantolo igxile kubo ngoba kusengenzakala ukuthi kunezinye izinto ke futhi ezenziwe kuso leso siqofo.
And it is not the same video footage which the investigating officer said he have sent it to the laboratory lab.
Kanti-ke futhi leso siqopho leso akusiyiso-ke lesi umseshi athe-ke uyiso anaso, kanti-ke usithumele koochwepheshe.
Therefore, this video footage haven't assisted the court anyway.
Kanti-ke leso siqopho-ke asisizange inkantolo.
And furthermore, his alibi defense was not tested before the court.
Kanti-ke ubufakazi bakho obuthulile ukuthi wena bowungekho lapho ngaleso sikhathi bokwenye indawo, lokho-ke akuzange-ke kwahlaziywa.
Court found that there were imminent threat towards the deceased.
Inkantolo ithole ukuthi yebo bekunokusabiswa kwakhe-ke umufi.
And this led the deceased to apply for the protection order.
Lokho kwenza-ke umufi ukuthi ahambe ayofaka isicelo sokuvikeleka enkantolo.
It is strange as why the applicant girlfriend had to share the photos, registration document, and personal details of the deceased with the applicant.
Kuyamanga ukuthi-ke intombi yakho kuza kanjani ukuthi-ke ithumele iy'thombe, iy'ncwadi zemoto zakhe-ke umufi athumela wena.
And is questionable because of later the deceased was killed.
Manje-ke kunembuzo elibuzwayo-ke lapho ngoba ekugcineni umufi-ke wase-ke wabulawa.
This court is aware that there is no onus on the bail applicant to disclose the defense, his defense, or to prove his innocence.
Kanti-ke inkantolo iyazi kahle namhlophe ukuthi ngeke esiceleni sakho sebheyili asimsebenzi wakho ukuthi-ke ubonise inkantolo ukuthi-ke wena-ke imaphi amaphuzu owathula enkundleni uma icala seliqhubeka.
Further, that the court hearing the application is not required to determine the guilty or the innocent of the applicant. That is the duty of the trial court.
Kanti-ke inkantolo iyazi kahle namhlophe ukuthi yona-ke umsebenzi wayo ukubheka ukuthi icala ngabe liyavuna noma liyalahla. Lokho kuwumsebenzi wenkantolo la icala liqhubeka khona.
However, one of the factors to consider is the strength of the state case.
Kanti-ke into-ke inkantolo ibhekisisa kabanzi ubufakazi lobu abashushisi abanabo.
It is apparent to this court that the state has a strong case, if not overwhelming case, against the applicant.
Kanti kuyacaca bha kwenkundla ukuthi-ke abashushisi banabo ubufakazi obuqinile mayelana-ke nalecala-ke leli obhekene nalo.
As the applicant was positively identified at the ID parade.
Njengokuthi-ke wena wakhonjwa okanye waqoshwa ngalesikhathi lesi kwenza-ke i-ID parade.
Furthermore, there is the witness who saw him at the scene of crime as he was seated with the shooter.
Kanti-ke phezu kwalokho-ke kunofakazi owakubona ngalesikhathi-ke lesi-ke wena uhleli-ke nomdubulo.
And he heard the applicant informing the shooter, there is the person, referring to the deceased.
Wakuzwa ngalesikhathi lesi-ke wena-ke utshela-ke laba banye kuhleli nabo ukuthi nangu lo muntu. Kanti-ke wawucacise lokho kumufi.
Photos, details of the deceased were found in applicant's form.
Iy'thombe nezinye izinto zakhe-ke zatholakala kumakhalekhikhini wakhe.
The proper approach for the court regarding bail will always be that it will grant bail where possible and will lean in favor and not against the liberty of the applicant if interest of justice will not be prejudiced.
Kanti-ke uma ngabe ubulungiswa ngeke kulahlekelwe wena iy'nqumo zakho zithule enkantolo zingakwenza ukuthi-ke inkundla ikhululeke nebheyili uma kuhambisana-ke nobulungiswa.
I have also warned myself of the fact that the court cannot authorize, permit, or prolong the detention of any person merely because of the society.
Kanti-ke inkantolo ibhekisisile ukuthi-ke angeke ihlalise isikhathi eside unqabele nesicelo sakho ngenxa yokuthi-ke kunezikhalazo-ke lapha ezingaphandle emphakathini
or police demand it,
nokanye amaphoyisa ke efuna ukwenza lokho
or for that matter, the offense against the applicant regarded as being of a serious nature.
kanti ke nokuthi ke icala leli liqine kangakanani na.
Section 60, subsection 9, states that the court shall decide the matter by weighing the interest of justice against the right of the accused to his personal liberty.
Kanti ke usection 60 ke wencwadi zomthetho subsection 9 uyathathisa ukuthi ke inkantolo ke kumele ke ibhekisise bese iyalinganisa phakathi kwesimo sakho kanti ke futhi ke nokulungisa.
And particularly the prejudice he or she is likely to suffer were to be detained in custody.
Kanti ke nokuthi ke uzolahlekelwa yini uma ngabe ke inkantolo igcina phakathi.
Court had to consider the provision of section 60 subsection 4A to E, whether or not it is in the interest of justice to release the accused.
Kanti ke inkantolo kumele ibhekisise ke futhi section 64A 4A so A and E ukuthi ngabe incomo zobulungiswa ngabe ziyavumela ukuthi makhulu.
In terms of section 60, subsection 4A, the court found that the applicant, if released on bail, will endanger the public safety, taking into consideration the degree of violence that was used during the commission of the offense.
Inkantolo mayibhekisisa leyo section A uyabona ukuthi ke laphayana umphakathi ke uzobe usengozini uma ke wena wakhululwayo. Uma kubheke kuqhathaniswa nokuthi ke umufi wabulawa ke ngodlame olunjani.
The prevalence of such offenses have been an epidemic in our society.
Kanti ke ujwayeleka kwale kwaso lesehlakalo lesi sokuyisifo khona ke emphakathini.
The fact that the applicant acted as a group in the commission of this offense daylighted against the defenseless person and firearm was used in the commission of the offense.
Kanti ke uma kubhekisiswa ukuthi wena ke nasebenza neqembu kukhanye emini kababa ngasikhathi kwenziwa lesehlakalo lesi esishaqisa umzimba.
There is a likelihood that applicant, should he be released on bail, he will evade the trial.
Inkantolo iyabhekisisa ke futhi ukuthi ke wena ke uma ungakhululwa ke ngebheyili ke wena kanti uzobalekela ke futhi lecala amathuba maningi.
He does not have a fixed address
Ngoba ke awunalo ikheli ekungela la uhlala khona.
because of he submitted different addresses.
Ngoba ke wena unikezele enkundleni ngamakheli ahlukile.
And therefore, it may be difficult for the state to trace him.
Lokho ke kwenza ukuthi ke abashushisi kube nzima ukuthi bakuthole.
I also take into consideration the strength of the case and the severity of punishment to be meted out if the accused is found guilty.
Kanti ke futhi ke ngibheke necala nokuthi ke icala ke nalo linjani mayelana nawe ke ngase ngibheka futhi ke nesigwebo uma ngabe icala liyakulahla ke isigwebo esinzima oyosithola mayelana nalo licala.
There is likelihood that he will interfere with the witnesses. The applicant know who are the witnesses of this case.
Kanti ke kuzokwenzeka ukuthi ke wena ke uhlukumeze okanye uphazamise ofakazi kulecala ngoba abofakazi balecala uyabazi.
The investigating officer emphasized the safety of the witnesses and said that the safety of the witnesses are at stake.
Kanti ke umseshi wecala uye wagcizelela mayelana nokuvikeleka kwabo ke ofakazi. Wathi ke ukuvikeleka kwabo kusengozini okanye kusengozini.
there is likelihood that he will jeopardize the functioning of criminal justice as there are outstanding suspects and he may interfere with the investigation.
Kungenzeka ke futhi ukuthi uphazamise ukusebenza kobulungiswa ngoba kusabonabanye ke abantu kumele babonwe mayelana nalo leli cala.
And that should the applicant be released, there is a likelihood it will disturb the public order or public peace.
Kanti ke uma ngabe ungakhululwa ke kuyacaca bha ukuthi ke wena ke uyophazamisa ke ukuthula ke laphana ke emphakathini.
This incident occurred in the public domain and community need to be protected from such violence.
Kanti ke lesehlala lo ke lesenzakale ke emphakathini kanti ke umphakathi ke wona kumele ke uvikele.
And as such, the applicant cannot be released back to the same society that he have offended.
Ngakho ke wena ke angeke ukhululwe ke ukuthi ubuyele kuwo lo mphakathi lo ohlukumezile.
This will lead to public to lose confidence in the justice system.
Lokho kuyokwenza umphakathi ungasabi nokwethemba ubulungisa.
The fact that the applicant says he intending to raise an alibi as a defense does not automatically convert his circumstances to be exceptional.
Kanti ke uthi ke wena kungekho ke lapho into yozivela ngayo lokho kakhulu kakhulu bhekisiswa kabanzi nesimo sakho.
The issues involving cautionary rule relating to single witnesses, identity, ID parade flaws, and the issue of video footage are all issues that need to be determined at the trial court.
Kanti ke ubufakazi ke bokuthi ke wena kunofakazi oyedwa kulecala ukuthi ngabe uwe ke noma ke le khomba lenkhala ngayo noma ke i-ID parade yona ke leyo noma video footage lokho siyokuyoxoxwa ngabo ngalesikhathi lesi ke icala seliqhubeka ke kundlela.
And have to be weighed up beyond reasonable doubt at that stage.
Kanti ke ngaso leso sikhathi kuyobhekisiswa abantu ukuthi ngabe lobo bufakazi buqadula ke ikhaya.
And this court will not make any credible finding of all issues as I have mentioned. I will leave them for the trial court.
Kanti ke njengoba sengizithintile zonke lapho wonke lapaphuzu lawo angeke ngigxile kuwo kakhulu lawo maphuzu ngizowabekela icala inkantolo le eyoqhula ke lecala.
State versus Mazibuko and the others, it was held that for the circumstances to qualify as sufficiently exceptional to justify the accused release on bail, it must be one way exceptionally heavy in favor of the accused, there rendering the case for his release on bail exceptionally strong or compelling.
Kanti ke uma kukhulunywa ngezizathu ezikhethekile ngalesikhathi kushushiswa ke uMazibuko inkundla ephakeme ke umahluleli wakhipha ke isinqumo esilandelayo ukuthi ke ukuze inkantolo ibonise ke umethuzana umfaka isicelo enkantolo abonise ukuthi kunezizathu ezikhethekile futhi nezokuqhela inkantolo ukuthi kumele abeke izizathu eziqadula ke ikhanda lezo izathu lezo zizwakale futhi zibe nesisindo zibonise ukuthi ke yebo kunezizathu ezikhethekile futhi nezixoxelela inkundla ukuthi imnikezeke ibheyili.
Therefore, the court found that there are no exceptional circumstances which in the interest of justice may permit his release. Therefore, his bail is denied.
Ngakho inkantolo ibona ukuthi ke wena ke awukwethulanga ke izathu ezikhethekile futhi neqoqelela inkantolo ukuthi ngakhulula ke ngebheyili. Ngakho ke inkantolo ibona ukuthi isicelo sakho ayisamukeli.
Lordship will request that this matter be postponed to the 11th of February back to the trial court.
Is it sufficient, Mr.
Just for order.
and to enable us to take further instructions on this matter and on the judgment to ship as copy this.
How about the 26th February for further investigations?
Our postponement has got nothing to do with further investigations. The 11th is more than enough time for us to obtain instructions. If there are standing investigations, obviously we know the matter will be postponed by the trial court for that purpose if it's in Warrick. That's my humble request.
Mr. Majola, please stand up. Case postponed to the 11th of February for investigation. You are in custody. You will appear in court number 23.
My better approach, Your
Yes.
I'm in attention. Thank you so much.
Be excused.
I want to make a request. I have another matter in your court. My request that this may be postponed because I have another matter to attend to in a different court. So I requested that I should be allowed to come here, Your Worship. It's a matter of my matter that's supposed to be for bail on effects. We just need to postpone for transcript and other stuff. So if I could be accommodated now before I do adjourn. Thank you so much.